This is amazing, really. 100 years of one convention, and we are still debating what's delivery, what's discharge, what does it mean, who is the carrier, what is carrier responsibility, from when to when, what is the time bar. It's all like it was drafted last week. It was drafted 100 years ago, and we are still debating, not us here, but even the Supreme Court in England last year. Well, my presentation today is, as the title says, has a lot to do with what we heard today, especially from Professor Thomas and Filippo. But I'll try to go into more specifics of the case, which is commenced by Finbank, a Maltese bank, known also in ship financing, which has financed a carriage of 85,500 metric tons of steam coal from Indonesia to a few, I think 2 Indian ports. Why was the bank commencing the dispute against the carrier? What the bank has to do with the carrier? Well, the bank is the assignee or pledgee of a number, I think 13 bills of exchange, which were issued by the carrier and which were all governed by English law. I don't want to go into detail, very painful details, why English law, because there are so many documents involved in this transaction. There was a charter party, obviously, for this carriage. There was a Congent Bill 1994 form, which says that all terms and conditions, including arbitration clause and governing law clause from the charter, are included, etc. Anyway, the bank has initiated arbitration in London, claiming damages. They lost money by financing this project. The carrier argues, well, the bank claim was time-bound, so they can't do anything against me. So it went to, as I said, to London arbitration. The bank wasn't happy with the result of the arbitration in London. They sought a leave to appeal, went to the High Court. They were not happy with the result in the High Court. They got a further leave to appeal to Court of Appeal. They were not happy with the result of the Court of Appeal decision. And finally, they ended up in the Supreme Court last year. So what were the bank's issues here in this case? Well, first, whether Article 3, Rule 6 of the Hague-Visby rules applies to claims for misdelivery of cargo or carriage after discharge has been completed. Just few sentences back. What happened with the cargo? Cargo was in India delivered to people who were not entitled to receive them without presentation of original bills of lading, and therefore they were treated as misdelivered. So the bank's case was claimed for damages caused by misdelivery of the cargo by the carrier. So that was the first question, whether time bar Rule 6 under the Hague rules and Hague-Visby rules applies to claims for misdelivery of cargo, which misdelivery took place after discharge. This is important, after discharge. Well, if it does, there is another issue. Whether Clause 2C of the Bill of Lading sets aside the application of the time bar provision in Article 3, Rule 6, after discharge was completed. Well, the bank claimed that since they had a bill of lading, they said that the actual terms of bill of lading are setting aside the terms of the Hague-Visby rules, including Article 3, Rule 6. And therefore, Article 3, Rule 6 doesn't apply, there is no time bar. That was Bank's argument. Let's see what happened. Just to remind you of the wording. I hate putting too much wording on the slide. It's very difficult to read and listen what I'm saying. But it's important to see the difference between same Rule 6 in the Hague rules and Hague-Visby rules. We heard already from our predecessors that in Rule 6 of the Hague rules, we're dealing with the discharging of all liability in respect of loss or damage. All liability in respect of loss or damage, unless suit is brought within 1 year after delivery. That slightly changed in Visby by introducing slightly different language, saying, again, the carrier and the ship shall in any event be discharged from all liability whatsoever, going into wider, stronger meaning of all liability. What all liability? Well, just to be 150% sure, whatsoever, any liability. But not only in respect of loss or damage, in respect of the goods. Anything, any liability whatsoever in respect of the goods. It can be anything in respect of the goods. It can be loss, it can be damage, it can be misdelivery, it can be all sorts of things. So this wider approach to Visby rules was quite important in this particular case. We'll see why later. Well, they went for ordinary meaning. Let's see what is the ordinary meaning of this particular wording. And the court referred to the case 2021 between Ali's 1954 and Allianz, called the CMA CGM Libra. I think it was mentioned earlier today, this case, where, among other things, it was stated that international conventions should in general be interpreted by reference to broad and general principles of interpretation, rather than any narrow domestic law principles. Well, this case is important for many reasons, but mainly because it's dealing with interpretation. As Professor Thomas mentioned earlier, wording is very important in English law. Very important. That's why they debated for a long time whether or not to introduce those words whatsoever in any event, or liability, loss, goods, no, just in respect of goods, anything in respect of goods. So words were very, this case is actually like a surgeon operation of the wording of the whole convention, but particularly of the wording of time bar wording, Article 3, Rule 6. The amendments to Hague-Visby rules suggest that the world was going for wide application, not narrow domestic interpretation, but for wide application by introducing the words in any event. Is liable in any event. Doesn't matter which event, any event. All liability whatsoever. Loss or damage in respect of the goods, or just damage to the, or any liability in respect of the goods. And discharge from all liability. It is the key here. And I think it is the key wording in any discussion about the purpose of the time bar provision. Why? Because the time bar leads to absolute finality. where these liabilities of the carrier arise from. The bank's case says carriage of goods definition in the Hague rules covers the period from the time when the goods are loaded on to the time when they are discharged from the ship. So what the bank was saying, let's look into the definition of the carriage of goods. That definition gives us what was the responsibility of the buyer. It's very clear. The responsibility of the buyer goes from the time of loading of cargo onto the ship until the discharge. What happened in this case was misdelivery, which happened after discharge. Therefore, Article 3, Rule 6 doesn't apply. That was bank case throughout the whole thing. Up to and including the delivery. That was the bank's case. However, I mentioned earlier finality. What is finality? Finality is the moment in time when there was no further action whatsoever available against the carrier. That's the moment in time when the carrier can say, that's it, all my accounts, all my books can now be closed. I can call my insurer, I can call my bank, I can call anybody saying, look, I'm now clean. There is no possibility whatsoever that somebody has a claim against me because the time period has passed. All related claims, including breach of rules, contract, or tort arising from carrier's liability for the goods. You see, this is the wide application of the Article Rule 6. It doesn't apply only in case of breach of the Hague rules or breach of contract. It applies in any event, which means even the carrier's liability arising from the tort as well. Maybe misdelivery is a tort. Delivering cargo to people who are not entitled. There is a lot of fraud, as we know, going around. And if with knowledge or without knowledge, delivering cargo to fraudsters can, can be qualified as tort. It doesn't mean that in that case, time bar rule doesn't apply. Well, even the tribunal said misdelivery post after discharge should have no special effect taking it outside the scope of Article 3, Rule 6 of the Hague rules. The tribunal didn't find any reason why misdelivery should be taken out from the scope of the whole time bar provision. A number of English authorities were taken into consideration here. One of them is, I'll just mention a few, is Aries Tanker, or the Aries Tanker Corporation against Total Transport. The House of Lords decided in that case that the time bar under Article 3, Rule 6 leads to absolute discharge of liability. Here we are. In the New York Star, delivery in relation to the time bar provision is directed towards the carrier's obligations as bailey of the goods. Article 3, Rule 6 covers post-discharge misdelivery claims. Again, what is delivery, what is the discharge? I don't want to go into the repertoire much because Professor Thomas go into many details, but one of the debates taking place in 1920s onwards was whether to use the word delivery or use the word discharge. In some older drafts, the wording was delivery of cargo from the ship, meaning physical operation, taking from the rail of the ship. That was changed, as we know, further to into delivery, meaning actually transfer of possession of the goods. And discharge stayed to mean a physical operation. So it's not the same thing. Therefore, carriage obligation is belly of the goods. What does that mean? That means that although the goods were discharged, he was still a bailee, and therefore had a statutory obligations and liability for the cargo, regardless that it was discharged, the discharge was completed. In Deep Sea Maritime Limited, Monjassa, Article 3, Rule 6, considering in any event all liability and finality applies to misdelivery claims. That was the decision. The time bar provision is not limited in its application to breaches of the Hague rules. It applies to all breaches of the carrier's duty, including tort of negligence occurring within the period of carrier's responsibility. As I said, I don't want to go much detail into travel repertoire. International case law was also considered very much in detail, but this presentation would last forever if I went to all details of that, as well as textbooks and commentaries. They were all considered very deeply in these proceedings, and the Supreme Court made the conclusions. Article 3, Rule 6, time bar in the Hague rules does apply to breaches of duty by the carrier which occur after discharge, but before or at time of delivery, including misdelivery. They also decided that Article 3, Rule 6, time bar in the Hague-Visby rules also apply to misdelivery. So after years of debate, since 2020, I think, because the cargo was misdelivered in 2018, and it took about 2 years to start proceedings. They took that risk not very seriously. Obviously, the Supreme Court has decided that actually the bank's claim was time-bound. I mentioned earlier that the second bank's case was that the terms of bill of exchange actually set aside the application of the Hague-Visby rules, including Article 3, Rule 6, time bar rule. Just to remind you of the wording of that provision. Article 2C of the Conjoint Bill 1994 reads, the carrier shall in no case be responsible for loss or damage to the cargo, howsoever arising, prior to loading, into and after discharge from the vessel. So the bank was saying, you see, again, the parties have agreed that only liability of the carrier during that period is something which can be relevant. Nothing what it says in the Article 3, Rule 6. Well, the court wasn't very happy with that interpretation. Oops, this is too early. The court said that doesn't make sense, that argument, because Article 2C, as it reads, gives a protection to the carrier. And they couldn't see the logics while arguing that Article 3, Rule 6, time bar, which is also protecting carrier, should be set aside by this provision. It is a bit puzzling. So anyway, further, the court said this provision you refer to in your application does not refer to Hague-Visby rules at all. It doesn't refer to carer's responsibility for misdelivery at all. Anyway, so that were the reasons why the court were not impressed with the bank's argument that this clause 2C of the Conjoint Bill actually sets aside the application of the time bar rule. Anyway, for all that reason, as I said, the Supreme Court decided to dismiss the bank's arguments, which I tried to present them here in a short period of time. And that was the end of that case, which I think grants lots of open area, but it also clears, in my view, lots of doubts about what is the period of carer's responsibility when the time bar is concerned. Let's not forget that the Article 3, Rule 6 is the only provision in Hague rules or Hague-Visby rules which deals with delivery. All other provisions are dealing with the discharge. So that also says something. That's it. That's for me.